Hi, I'm Skip Reynolds with Skipton Law, Estate Planning and Elder Law here in Centennial, Colorado. And on today's video, I want to talk briefly about giving, or what we call in our office, gifting of money or assets. See, many people know of what we call the annual gift allowance, which this year in 2022 is $16,000. And my understanding is for 2023, it will be $17,000. Some of us might remember that being $10,000 or $14,000 or $15,000, but here in 2022, again, it is $16,000. So many of us are aware of this, but we are concerned about giving our children more money for a down payment on their house or to start a business or whatever it might be for, because we're concerned that if we give money above that annual amount, we will owe taxes or they will owe taxes. And it's because many of us are not aware of what we call the lifetime gift exclusion amount. So way back in 2011, the federal government unified what we can die with what we can give away with during our life, above and beyond the annual gifting amount. So here in 2022, you can die with $12,060,000, but we also have a lifetime gift exclusion of $12,060,000. So in theory, you could give away, if you had less than $12 million, your entire estate, and there would be zero federal gift tax owed. Now, don't go out there and go and gift away your assets. That's not what I'm saying. You still need professional advice before you do any of this. But in theory, you can do that without any gift tax consequences. Really, what the government wants to do is they just want to track it. So here's what I mean. Let's say that someone gave me $200,000. And it was from one individual. So the first $16,000 would not be counted. So that leaves $184,000 that would need to be accounted for. And here's what the government wants. They want you to file a federal gift tax form notifying them that you gave away $184,000 too much that year above the annual gift exclusion, so that they can subtract $184,000 from what you can die with, which is $12,060,000. And $184,000 from what you can give away during your lifetime, which is $12,060,000 this year. They just want to track it. It's not that you can't do it, it's more that they want to track it. Now beware, depending on the type of asset you give away, and we'll talk about that in other blogs, depending on the assets that you give away, there may or may not be other tax consequences, whether it be income tax or capital gains tax consequences, depending on what that asset is that's being given away. But be aware, you can give more if you wanted to. But I always recommend that you talk with your tax advisor, your financial advisor, and even your attorney before you do these things. Again, if you like this content and you'd like to hear more content like this, you can go to our YouTube channel. Or if you'd like to come to one of our bi-monthly workshops where we talk about giving, we talk about wills and trusts and powers of attorney and how to protect our estate from things like the nursing home. If you'd like to attend one of those, there's two ways that you could sign up here in Colorado. You can go to our website, which is skiptonlaw.com. Click on the resource tab and then go to workshops, and the dates are there. You can sign up right there, or you can call our office at 720-440-2774, and we get you signed up that way as well. So hopefully you enjoy this content. Again, my name is Skip Reynolds with Skipton Law, Estate Planning and Elder Law here in Centennial, Colorado. Thanks so much for joining me. Have a great day, everybody.